Appeal number 145, the People versus Lerio Guerrero.
Good afternoon. My name is Glenn Garber, and I represent appellant Lerio Guerrero. I would request 2 minutes for rebuttal, if I could have it.
You may, Mr. Garber.
Thank you. This is an appeal before this court based on leave that was granted by a justice of this court. And I'm going to start with a quote from People versus Perez. It's a 1994 case out of this court. And this is the quote. Section 6 of Article 1 of the state constitution guarantees individuals the right to indictment by a grand jury before being tried for an infamous crime. That requirement, rooted in the belief that the public should have a check against the potential abuse of power by those vested with the prosecutorial authority of the state, is a matter of public, fundamental rights fixed by the Constitution, not one of policy, expedience, or convenience as a district attorney or judge may see it. That quote puts into focus the problem that is presented in this appeal. Here, and just to kind of back up a little bit, the right to a grand jury, although notice is a big thing that gets discussed in the briefs here, this is not a problem with notice. This is a problem with presenting sufficient evidence to a grand jury linking the defendant to the crime.
Does that survive a plea?
That does survive a plea, and I believe that the law is clear that that type of an error, the identity of the defendant, a critical piece of evidence that is lacking in a grand jury proceeding, is one of constitutional dimension and is fundamental, and that survives a guilty plea.
What should the DA have done in your view?
In this case? Well, what the DA should have done was they should have, first of all, indicted the case, within the 5-year period of time, okay? And then once and then they should have went back and presented the case to a grand jury again after the defendant got arrested and they were able to make a link.
So let me ask this. So you're not arguing that you can't have a John Doe indictment?
I'm not, that's the notice problem. I do think there's issues with that, but the law is fairly clear that that's okay, and that may start.
So let me take the next logical step then. So what's the difference between a John Doe indictment and substituting the DNA indictment?
Okay, the problem here is it's not a facial issue. Mm-hmm. What happened is, and there's sort of a number of moving parts. So you have the amendment to the indictment. And I'm putting the statute of limitations issue aside for a moment because it's 12
Which is really all that's in front of us, is the amended indictment, not the original indictment.
Well, correct. Well, I'm not sure. I think the whole package is in front of you. What you have is a DNA indictment that is then re-upped or put back into play by this amendment, and it's the matter of the amendment that probably is the key problem here. Because instead of going...
if it had never been amended and we were just talking about a statute of limitations problem, you wouldn't be arguing that the DNA indictment was insufficient?
Well, the argument below was that it was insufficient, and People versus Martinez, which is, I guess, the key case in New York out of the First Department, says there's no notice problem. So I don't know if we would be making that argument, but here what happens is the amendment. That's the issue that gets preserved, and that's what I was trying to tee up with that quote.
Correct me if I'm misunderstanding your argument. I thought your argument is that you've got this John Doe indictment, and now they want to amend it to connect the defendant, to identify the defendant as the person who was previously called John Doe, because it's based on this DNA identifier. And that's all well and good. The DA could do that, but they can't do that through this kind of hearsay evidence
exactly
that they
right.
used here.
Okay,
so now we're going to get back to Judge Faye's question. What should they have done? What should they have done other than use this hearsay evidence? Because
I don't know what they could have,
argument, right?
under these circumstances,
Yes.
I don't know what they could have done, okay? Because here it's 12 and a half.
Did they need to bring in the person who matched the DNA, or
They
someone
needed to
who would
bring
match
in
the DNA?
the affirmation by the prosecution that says, and I think I have it right here, it's page 121 of the appellate record, says, I spoke, and I'm going to summarize because time, okay? I spoke to this police officer. He recovered a cigarette butt from Mr. Guerrero, and the DNA swab was taken from that. Then I spoke to someone from the OCME who tested that and then made a comparison between the profile on that cigarette butt and the crime scene evidence.
So is that who they needed to bring into the grand jury?
They needed to, that's evidence. That's DNA. It may be very strong evidence. It may be, there would have gotten an indictment, no matter what, prognosis bad for a no true bill there, but they have to do it.
Well, why can't they just go with the hearsay, and that's something you can challenge at trial?
Because it's an identification. So it's akin to, and there was a quote from the trial counsel on this, it's akin to, we have a description of the perpetrator, and then they arrest the defendant a few months later, and then instead of, and then the lineup's done. And then the defendant is picked out of the lineup. And instead of putting that lineup evidence into the grand jury to make the link, they put in an affidavit that says, I viewed a lineup, and that lineup showed that the defendant was picked out. It's the same, DNA evidence
It's
is...
a motion to amend, right? They're not in front of the grand jury, or am I reading that wrong?
Well, what effectively happened was the motion to amend circumvented this critical part of a grand jury proceeding.
So I thought your argument was that what they should have done was go in the grand jury with this.
Well,
But they didn't. But is your argument that even if this is a proper motion to amend, that this is not sufficient to support it?
Well, it can never, I hope I'm getting the question properly, this could never have been a proper motion to amend based on the way they did it. They would have, because of the nature of the evidence and linking the defendant to the crime scene, you got evidence from the defendant, his buccal swab and DNA profile, you got the rape kit, you got to make that link. You can't do it.
I understand the evidentiary issue, but so let's go back to an earlier question on, you indicted under Joe Smith. Turns out that's an alias. It's actually Joe Jones. I make a motion to amend. I'm the prosecutor. I make a motion to amend. I have a hearsay establishing that actually this alias belongs to Joe Jones. They grant the motion to amend. Would that be the same problem? Do you have a problem here because it's DNA?
I have a problem here because the DNA becomes the identifying piece of evidence that links the defendant
Joe Smith was the identifying evidence there, and at trial, the people are going to have to prove, actually, Joe Jones and Joe Smith are the same person. But it doesn't mean they have to put non-hearsay evidence in to amend the indictment.
Well, that's a technical problem with the face of the indictment that has nothing to do with the fundamental
I'm not
proof.
Joe Jones. I don't know who that is.
Well, okay.
I'm not DNA sequence, whatever. I don't know who that is either.
But it's a way you look at this, I guess, if you say, look, a DNA profile is akin to a human being and an identification of that human being without making the link between the defendant's DNA and the DNA from the crime scene, which is what they argue, then you're basically saying, you know what? That form of evidence, DNA match, okay, we can take judicial notice of it, and we don't need to go before a grand jury, we don't need to prove that connection, and you're tampering with the function of the citizens, which is to put their imprimatur of, yes, this case can go forward because we are a fact finder, we've seen it.
If they had identified the defendant originally and wanted to use DNA before the grand jury, could they have done it through hearsay, or would they have had to call these people to begin? Let's say, no, it's the defendant, and now they want to connect, they want to use this DNA as part of the evidence they present to the grand jury.
If they've already made a sufficient factual link between the crime scene evidence and the defendant,
Yes.
say the defendant is the perpetrator for this crime through, let's say, ID, okay,
Yeah.
I don't know why they would need to then put in hearsay DNA evidence,
No,
but I
originally-
don't think they could do that. I mean,
I'm sorry, let's start with the first grand jury, or the grand jury that heard this and issued the indictment, right? So
yes.
let's say the prosecutor knows it's or thinks it's the defendant, that's the person they want charged, has the DNA, they want to present that also to the grand jury. So my question was, could they have done it the way they've done it here in the
No.
amendment? Or would they have had to have called in the person who has compared the DNA and the police officer
They would
with
have
the
had it-
cigarette butt? That's my question.
I think the answer is they would have to do it through live testimony, just like they would any other form of identification.
Thank you, sir.
So the defendant uses a false name. You go in, you bring a motion to substitute the accurate name, the DA does. That's unquestionably allowed under our jurisprudence.
A false name under our jurisprudence, that is considered to be a technical defect to the face of the indictment, not the underlying proof.
Right, but we're not talking here about, we're talking about DNA as an identifier. DNA is certainly a better identifier than a name. So that's the problem, with the logic I have your argument. I understand your argument the other way, which is that you're basically saying he wasn't indicted by the grand jury at all on this proof. That's the side of your argument.
Not Guerrero, okay, a DNA profile was indicted as a
but not
first
Guerrero.
step. It's a half indictment came down against a DNA profile, but the link, the evidentiary link, the identification procedure, which happens to be DNA here, the match, okay, was not presented to a grand jury in an appropriate way, and the state, or the prosecution, essentially just put it through without going to the citizens, which is the grand jury, and that's a function.
I think your underlying argument, counsel, on the name thing is that Sheila Abdul Salam was indicted, whether the name used was Sheila Abdul Salam or Sheila Blow or, Sheila whoever, or a different name, but the person, Sheila Abdul Salam, was indicted, but not DNA, not with the DNA. Is that basically your argument?
Well, I hope I'm getting this right, because the name does not matter that much. As long as they bring
That's what I
the
mean.
right defendant to trial, the notice requirement has been satisfied, the name is not that relevant, that's a facial issue. Due process is not violated, because now the defendant knows, these are my charges, I'm in court, whatever my name is really doesn't matter here, I'm going forward and fighting these charges. This is different. This is a fundamental piece of evidence that has to go before a fact-finding grand jury, and it hasn't. And I know I'm over my time, I
May I
apologize.
ask a
One more question.
Thank you. So then, just to clarify, so then your point sort of in these hypotheticals about the different name or a false name, is your point that there's something defective in the identifier, but in the DNA, their position is there's nothing defective in the identifier. They're simply linking to a person.
I'm saying, okay, they're saying that the identifier itself, I believe this is their argument, this was not their argument below, but this is their argument in this court, that identifier is enough. That DNA indictment is so specific that it's akin to...
But the point is that the identifier is correct, as opposed to in these
It may
other...
be.
What I'm saying is, in these other hypotheticals, I thought in part you were arguing that the identifier has a defect that's technical, and that's what you're correcting, versus the identifier is accurate. It's got to be, someone has that DNA. Let me try it that way. Someone has that DNA. And maybe at trial, your client is going to say, well, that's not my DNA. But you're saying the grand jury's got to decide whether or not, based on the evidence they have, and you're saying it's not through hearsay, it should be live testimony, this DNA, for whoever the first grand jury said, that's the person who needs to be brought up on these charges, is this person. That's the live
Correct.
testimony one,
And that...
as opposed to a defect in the identifier initially.
But it's a defect of factual proof, okay? So it's not a facial problem with the indictment, okay? I mean, at least we're not arguing that it is. We're arguing that it's a defect in there's a gap in proof here. And this was a developing thing. This was a rolling thing that was happening throughout the United States. And now they're repealing the statutes of limitations in these cases to obviate this and other problems. So,
Thank you, sir. Counsel?
May it please the court, Malancha Chanda for the people.
Counsel, before you start, I'm sorry to interrupt you,
Sure.
but could you help shed some light on this difference between I indict under John Doe, it turns out the person is John Smith,
Right.
and later on I come in for a technical indictment and I want to link John Smith to the John Doe alias. What's the difference?
There is no difference. There's no meaningful difference. It really turns on whom the grand jury intended to indict. And this court has held that in People versus Bogdanov, has recognized that what is the identity or who's the person the grand jury intended to indict. And if the name was incorrect, because as in Gannett, a case I cited in my brief, in that case, the police officer didn't know his correct name, but said, this is the guy who sold me heroin on a specific date. And then later it comes out that, no, that guy's name is different. You could do it by a motion to amend with extraneous evidence.
Can you do it the other way? Can you move to amend to add an alias?
I'm sorry,
Can you move to amend to add an alias?
Sure, because that's developed through extraneous proof that you find out by birth records or arrest records that the defendant has used another name, and you put that in.
So the first name is the correct name, the correct identifier. Joe Smith is the name, but you find out this person's using the name Joe Jones. You can file an amendment to add the Joe Jones?
I would assume it's AKA, also known as Joe Jones, alias.
This motion to amend is on notice?
I'm sorry?
The motion to amend
Yes,
is on notice.
yes. And,
But the question here is how you present this, so that you can connect this defendant to the identifier, right? Because it is not like those other cases. The identifier, you say, is not defective. That's not wrong.
Right.
The identifier is right. We
Right.
don't know who is this person. We can't find this
This
person who has
matches
this
the-
unique DNA.
Right.
Aha, now we found them many years later, and now we want to, of course,
Right.
proceed against this person.
right, and under the CPL 200.70 that says when there are variances in proof that deal with names of persons or places, you can do it by amendment anytime before or at trial. And that's what was done here. This motion and.
Yeah, but it isn't, I take it the people's point is really you can only do this at trial, and that's where this is where the rubber hits the road. So but he wants to say you've got to use live testimony, because the grand jury needs to observe them and make their decision based on that, not on hearsay, and so-and-so told me this, and so-and-so told me they did that. That's his point, which is not about the defectiveness of the initial identifier.
Well, and correct me if I'm
Right,
wrong, Your Honor.
I don't think he's sitting around saying the DNA is defective in the sense it's not accurately identifying the perpetrator, right?
I think he's
that at
saying
this
it's
point.
insufficient proof, my
That
understanding.
connects to the defendant.
Right, and in this case, putting aside the fact that he pled guilty and he admitted that the DNA profile belonged to him, what happened was there was testimony that this DNA could have belonged to only one of 1 trillion people, and that's 200 worlds. So
Right,
now
but I
you-
don't think that's his argument. His argument is you could do that, you just got to do that with live testimony. He's not challenging that, right? Let's say we hold against you, what would you do? What will happen the day after this comes down if we agree with them? You can't do this through this kind of hearsay motion.
Well,
What would the DA's office do?
I think we are barred by the statute of limitations.
No, not in his case.
Oh, I'm
As
sorry.
a general matter, moving forward with these DNA John Doe, to the extent you need them, that, you've got these statute of limitations problems.
Sure, I mean, in this case or similar cases with DNA that involve rape or criminal sex acts, I think the legislature has abolished the statute of limitations, so presumably we have much longer time.
You don't have to concern yourself with it that way.
Even in this case, counsel, you say then it's over. If you have good cause, wouldn't you be able to represent the case to the grand jury?
Well, yes, because the statute of limitations technically has not expired with respect to a number of these charges, so we would be able to do that.
Well, the reason I asked about notice is it seems to me that the problem gets cured that way. If I came in and said that was not my cigarette butt, or if I came in and said, I don't know where you got this, you must have picked up the wrong file and associated it with the wrong DNA, that is aired before the court before you're allowed to do the amendment, right?
Right, and in this case, I believe the only objection was that it was an improper procedure by doing it by the motion. There was nothing going to the substance of whether it was not his DNA or whether there was a problem with obtaining the DNA. My understanding is there wasn't an objection to that. It was just by the procedure.
Are you saying that essentially, when you have a DNA John Doe indictment, that's a way of putting a label on somebody who did this, okay? And that it's really no different than if you put the wrong name on the somebody who did this. So that the DNA John Doe is, even though the DNA is technically correct,
Right.
It's not how we normally identify somebody. So it's sort of like an alias that is, maybe technically correct, but that's not how we
Well,
identify.
I believe in Bogdanov, this court said you wouldn't even have to amend. You could disregard it. You could proceed with a DNA indictment with the profile, and at trial, that would be, if that were in question, that would be something that would be resolved and debated, and the people would be put to the proof on that. But we wouldn't even have to amend. So this amendment could have not been granted, and it would have been fine to proceed with the DNA indictment with the profile.
Let me ask you, if you would again clarify this. If it's just an error in the name, just an error in the name, what's the supporting documentation for the motion?
You're showing theoretic, just in the abstract, not in this case.
Not in this case,
Right.
it's not about the name.
Right,
There is no
because
name.
there's no error here.
Well, there's John Doe, but there's
I would
that's
assume
fine.
that there is some documentation about through what search or discovery led the police to the proper name.
Is that an affidavit by the person, or is that the ADA's affirmation? What is the supporting documentation you put in?
I would assume there could be an affirmation and documentation concerning criminal history records. Maybe defendant wants to say, this is my name, and I want to affirm that I am not the person who is charged.
Let's assume they're not doing that.
Okay, right. But the people will put in an affirmation, probably support it with documentation through a search of what has led them.
So here, there's only hearsay? There's not affidavits attached?
I believe it's just an affirmation.
Yeah, why not do the affidavits here if you might do them, if you might use these other supporting documentations if it's just a name problem?
I'm sorry,
Would that perhaps resolve this? Let's say the court thinks that, well, you can't use hearsay that's in that way. Right? You want, forget the life testimony for one moment. We just don't like this saying so-and-so told me so-and-so. Right?
Right. I have to go
You
back.
have the under oath statement in writing. Mm-hmm.
I
The reason
believe
you
it
couldn't
was
do that
based-
if you're doing supporting documentation for other kinds of John Doe indictments? Am I
I
misunderstanding
mean,
the
the
whole
main
process?
thing is, like, extraneous evidence is permitted. It doesn't, the statute certainly doesn't limit the type of evidence. It just says the extraneous evidence to make non-substantive changes in variances of proof.
Counsel,
with
how
his
did
name.
this indictment effectively charge this defendant and put him on notice?
I'm sorry, how did it set
Effectively
forth?
charge him and...
It set forth each of the charges and specified the charges and set forth all the elements and the facts supporting those material elements and provided him with notice. And presumably when he was arraigned on it is when he had notice of the charges against him, and he's not contesting that he had notice of the charges against him. And the indictment fulfilled its jurisdictional requirements by providing that notice. Whether a specific type of, a form of the caption is not a jurisdictional issue, and so it's not before this court because of his guilty plea. And again, the grand jury testimony established that this DNA, which was taken from the victim, couldn't have belonged to anyone but 1 out of 1 trillion people in this world, which is only 5 billion.
But in this case, the grand jury did not have an opportunity to assess your evidence that links the defendant to this identifier. Is that correct?
Again, the grand jury
If
intended
you had knew, well, the answer is yes, correct?
Well, yes, no, the grand jury intended to indict a specific
No,
person.
I understand that, but
And that link-
that grand jury did not have the opportunity to assess your linking evidence,
But
correct?
it was not required under
But
CPL.
it's just a yes or no.
No.
Okay, that's fine.
Okay.
All right. So let me ask you this. It was the question I asked him before, and I'm gone past the time. If the chief judge will just allow me this one question. So let's say you had linked him up before the indictment, but you were going to present this DNA evidence to the grand jury. You would have done that with live testimony, with the human beings that connect him? Or would you not have done that?
Do you mean that would we have presented just what we did in this case, even if we had made the match?
If you had, you're right, if you had the DNA.
I would not, I can't understand why we would not put evidence of that match in before the grand jury.
Grand jury. So you would have called someone from OCME and
Right.
the police officers, got
And
the cigarette
explained-
butt, whatever whatever
Exactly.
way you would have chosen to link that.
Sure.
Correct. Okay,
Thank you.
If we had that, yes.
Thank you,
And
counsel.
unless there are any other questions. Okay,
Thank
thank you.
Mr. Garber, get back to Judge Garcia's question. When you have a witness in the grand jury who affirmatively misidentifies the defendant by name, it's the right defendant, affirmatively misidentifies him, calls the person Jim Johnson. The indictment charges Jim Johnson. The police go out and pick up Jim Johnson. They run his rap sheet. It turns out it's John Jones. The people move to amend the indictment to reflect the appropriate name. How does that differ from what we have here?
In that situation, there's no doubt that the person who was, let's say, identified in the precinct and who was being brought into court under the indictment by the wrong is the same person. They've already made the sufficient link. So there's no doubt.
Outside of the grand jury's presence?
No, it would have been done inside the grand jury's. I'm assuming in that scenario, an identification has already been done of, are you saying, well, how is the identification in that case done? Through?
But they've already done that part.
Through
with
a
the
photograph.
DNA. No, with the DNA, because they've already gone in and said to the grand jury, I suspect, that this DNA profile matched this evidence. So they've indicted that profile the way you say, and the chief, I think, is getting at, the chief judge, they indicted Joe Jones. Because it's the equivalent of that initial testimony that you're saying is missing here, but it's the equivalent of that initial testimony, I saw Joe Jones commit this crime. This is probable cause to believe Joe Jones committed this crime. They went in the grand jury and they said, this is probable cause. I'm assuming they proved to the grand jury, whatever, the standard. This is DNA profile X. And they indicted DNA profile X, just like they indicted Joe Jones. Later, they find out DNA X has this name, and they amend the indictment. The same way later, they find out Joe Jones is actually Joe Smith. You're confusing the second link with the first indictment, is my problem with what your answer to the question.
In the Joe Jones situation, there still would have been an identification of a human being, whatever that human being's name is.
So it's the fact that it's a number versus a name?
But why is the DNA profile from the rape kit, okay, the same as an that's definitely the guy, okay? That's definitely the guy who we haven't found yet. Okay, that's, if you go back to the first...
Why isn't the DNA profile the guy that we haven't
well,
found
I don't
yet?
think
That's
that you
the
can...
question.
Then the court then takes judicial notice of the fact that a DNA profile can only mean one person out there in the world,
Well,
and
that was
we're done.
That
We're
was
done.
testified to the grand jury, that one in however many billion.
Yeah, but it's still DNA evidence. Okay, that DNA evidence may be challenged at a trial or at some other proceeding,
Could they have
but if
gone
the court...
to trial? Could the people have gone to trial without amending the indictment? Couldn't they have gone to trial without amending the indictment?
Not without linking the defendant to
Well,
the
they
crime.
can link him at the trial.
Right.
Couldn't they link him
They
at the
link
trial?
him through the DNA. They say that
at the trial.
but that's the identification at the trial that has to be done. They're acknowledging they have to do it at the trial, but they don't have to do it to the grand jury for some reason.
Well,
it's still a factual link.
If you agree that they could go, I mean, it may be a risk, but with DNA, probably not that huge a risk. If the DNA, if they believe that this cigarette matches the DNA that was indicted, they could go to trial and try to prove that.
Okay, there's also a chain of custody problem here, by the way.
Well,
that's never even addressed
isn't that
in the
an
grand jury,
evidentiary-
too. But this is a conundrum.
But
because
isn't that an evidentiary problem? That's the genesis of my
But-
question
but-
here. If they go to trial on it, they have to prove
what
their
evidence?
case.
I think you're on dangerous ground, basically saying, look, DNA is so powerful, and
No,
the
we're just
profile
saying-
is so identifying that we don't have to link it to
No,
the
they're just saying,
person.
they're just saying that it's a charge. I mean, if I identify you as the murderer, you're going to get indicted. Now, if I made a mistake on that, you're going to get acquitted. But the fact of the matter is that, based upon my identification, the jury thought that there was enough there to charge you with murder. Could be wrong. Could be the wrong person. But that's what a grand jury does.
Yeah, but the link, the identifying fact, evidence, it's DNA evidence. It's not DNA, supernatural stuff that
It's evidence.
courts can take judicial notice of.
It's evidence.
And then it's evidence. So if it's evidence that connects the defendant to the crime, it has to go before a grand jury.
It's an identifier. It's like an alias in a way, but it's stronger, but it's the same thing as an alias. You go in the grand jury, you indict under an alias. You think it's the right name. You could go through the entire trial and convict under the alias, and you would still have been indicted by the grand jury, even though you come forward later and say, my real name isn't that.
Yeah, but there's sufficient proof that that person
At
is
trial.
the same guy on trial.
At trial. And that's a trial issue. So here they did the same thing. It's almost like just substitute an alias or the real name for this DNA. And later, you may learn that this defendant used an alias. I want to use that. I move to amend. The indictment has the right name in it. It's not an error, but I want to add an alias. So I move to amend and I add the alias. At trial, I'm going to have to prove to this jury that you, who I indicted under your real name, used this alias in committing the crime. Why is that different?
In that situation, and I've been there many times, where you say, my client's name is wrong, or the name is wrong, and there's an amendment by consent, nobody even says anything, it's a ministerial thing, no big deal. This is different because it's identifying, and I think what at the core of this is that profile that is recovered from the rape kit, is that akin to a human being? Okay? Is that profile the same as a human being? Even though
That's the issue of, was the original indictment good or not?
Yeah, and they amended it through that hearsay affidavit, not like saying, this is just a ministerial thing and this is the guy. They actually put in the chain of custody and all the other stuff to make the link.
Counsel, you're not contesting that they could indict on the DNA number. You've conceded that. Your problem is linking your client to that number that they indicted.
Because I'm making an argument that's not, I don't think it's been made that frequently. I don't know if it's been made at all, other than in this case where it's about the underlying sufficiency of the evidence, the link, not the facial indictment itself and the DNA probe. I think that procedure is bizarre, by the way, to indict a code. I understand that they're strapped. They want to move forward. But I can't attack that because the law says there's no problem with notice on that, and I would be laughed out of this court
Do you get your opportunity at trial?
if I attacked it.
Do you get your opportunity at trial to attack that?
You do, to attack the link, the match, but that doesn't mean that the citizens don't pass on that critical factual piece in the grand jury. Where do you draw the line? Can you indict a picture? Can you indict a fingerprint? Can you say those are enough?
That's the original indictment issue again.
Yep.
Can you indict a DNA profile is not the issue you have.
But a fingerprint, we hearsay fingerprint linking the defendant. Here's a picture through an affidavit. That's enough to make the link. Where do you draw the line? DNA, powerful. Prognosis negative for no true bill. Prognosis negative for acquittal. But that doesn't mean that you just say, you know what? I'm the prosecutor. I have DNA evidence. Here's an affidavit. Scares everybody with all the alleles and everything. That's enough. You don't have to go before the grand jury. The citizens don't have to pass on it. We're okay with that. I think it's a problem because you have to draw the line and say the grand jury is not just about notice and avoiding double jeopardy so you know what you've been charged with. It's also the citizens considering evidence that links the defendant to the crime, and it's a check on governmental authority.
Thank you, Mr. Garber.
And the statute of limitations problem, sorry.
Thank you.